Today I will be discussing custody of a child. What is custody? Custody is the right to make major long-term decisions for a child, especially those in connection with the child's medical care, education, moral and religious upbringing. Now, actual custody is also called care and control. This is the right and duty to look after a child on a day-to-day basis. Now, the duration of custody. Custody lasts until the age of 18 years or until marriage, whichever comes first. Entitlement to custody. Today, the entitlement to custody vests in both parents and guardians formally appointed as governed by the Custody, Guardianship and Maintenance Act of Guyana. Now, each parent has the right to the physical possession of his or her child. Now, the entitlement to custody applies to a child born in wedlock and out of wedlock. A child born in wedlock is whereby each parent is married to each other, and a child born out of wedlock is where the parents are not married to each other. Now, you may ask which court to apply to when seeking custody for a child. Now, if the parents cannot agree on a question in relation to the welfare of the child, they may apply to the High Court for a decision. The High Court can make any order in relation to the custody of a child born in and out of wedlock. The Magistrates Court also has the power to make any order in relation to custody of a child in a marriage while under 16 years. In custody cases, the first consideration is the welfare of the child, but it's important to note that the welfare of the child is not the only consideration. Now, the Act, the Custody, Guardianship and Maintenance Act, also sets out several considerations that the courts will take into consideration when determining the welfare of the child. These considerations include the age and sex of the child, the wishes of the child, keeping the siblings together, the personality and conduct of the parent, the need to protect the child from any abuse and or harm, and any other relevant considerations. Now, some key takeaways. If a parent dies, the surviving parent will have all parental rights of that child, or if a guardian was appointed by the court or by the deceased parent to act with the surviving parent on behalf of the child. Now, a step-parent has no right to custody of his or her stepchild. When a child is adopted, the parental rights pass from the natural parents to the adoptive parents. Now, in divorce proceedings, the court can make a joint custody order where the child will live with one parent, but both parents can make major long-term decisions for that child. In non-divorce proceedings, the court cannot make an order to joint custody. When a custody order has been made in divorce proceedings, the child must not be taken out of Guyana unless the court gives permission or the other parent gives written consent. At any stage in divorce proceedings, either parent can apply to the court for an order stopping the other parent from taking the child out of the jurisdiction. The parent with custody cannot change the surname of the child except with the judge's permission or the written consent of the other parent. This has brought us to the end of today's discourse.